Supreme Court of the State of Colorado is now in session. Chief Justice Coates presiding.
Please be seated. You can tell it's easier for you to work your chairs than it is for me to work mine. So, first case on the docket for this afternoon is captioned Carousel Farms Metro District versus Woodcrest Homes. We've set this argument for an hour. You all know you're going to have to keep track of your own time. The clock counts down. We've got a little bit of a situation. We granted an order for Woodcrest to share your time with amicus curiae, and that's broken up as 20 minutes for you and 10 minutes for the amicus curiae. And folks better at this than I think we've arranged the clock. So yours will show a caution light with 7 minutes left, and the 10-minute argument will show a caution light with 3 minutes left. All right. Petitioner, when you're ready, begin your argument.
Good afternoon. May it please the court. My name is Carrie Bernstein. I am an attorney at the law firm of Alderman Bernstein, and with me at council table is my law partner, Jody Alderman, and we represent the petitioner, the Carousel Farms Metropolitan District in this matter. There are 3 reasons why this court must reverse the Court of Appeals opinion. First, the Court of Appeals applied the wrong standard of review to a fact-intensive inquiry into public use. Second, the Court of Appeal added a new condition precedent to a Metro District's exercise of its eminent domain power, that there must be a subdivision approval before property is condemned, which doesn't exist in eminent domain law or the special district statutes. And third, the Colorado Court of Appeals misapplied the plain language of a statute that prohibits a transfer of condemned property to a private entity when here there was no transfer that happened to a private entity. First, I'd like to start with the standard of review issue. And the public use determination in condemnation and the bad faith inquiry and condemnation is a very fact-intensive inquiry made by the trial court. And it's a case-by-case inquiry, and there's a rather complex factual test that the trial court undergoes in determining whether or not there is a public use in a takings case or if there's bad faith existing in a takings case. And the test is, the trial court's role in this inquiry is to determine whether the essential purpose of the taking is to obtain a public benefit. And if it essentially is for a public purpose, then there will be found to be a public use. There can be incidental private benefits, but that doesn't defeat a public use. And the trial court is tasked with looking at 4 different factors in its public use determination. It looks at the land's physical condition, the community's needs, the character of the benefit conferred on the community, and the improvements necessity in developing states' resources. And courts have liberally construed what public use is. There are a lot of there's a lot of case law from this court and the lower court that says that that's the test, and it's a very factually specific test here. And of course, along with that test, all of the cases that have come out of this court and the Court of Appeals have said that the standard of review for an appellate court is the clear error standard. That has been established in case after case after case, and here really the Court of Appeals reversed that established case law. And And it provides the opportunity now for any public use determination made by the trial court to be reviewed de novo, essentially, by the Court of Appeals.
Ms. Bernstein, may I ask, it strikes me that there is a middle ground here. I understand your argument, but why isn't this a mixed question? We defer to the factual findings about what happened on all those factors you talked about, but the ultimate application of the law to the facts strikes me as more legal in nature. So why isn't this a mixed question?
I don't think there's a dispute here that the correct legal test was applied by Judge Cachette at the trial court level, as well as the Court of Appeals. So there's not a question of whether or not there is some sort of error in the law that was applied, but the facts, the very specific facts to this case and to any condemnation case needed to be dealt through, and that's what the trial court did.
Sure, but I'm drawing a distinction between the facts and the conclusion, which strikes me as a conclusion that there was a public purpose or not. That strikes me as more, and not a standard of the legal standard question. That just strikes me as the conclusion that there was a public purpose based on the facts that the court found.
Well, and I think that conclusion is a factual conclusion.
Okay, and that's what I'm trying to get to. Why?
Why? Because you have to look at all of the circumstances surrounding the taking in each particular condemnation case. And it's hard to, and the court has to really delve into all of the facts leading up to the decision for the taking and all of the reasons for the taking, and looking at private benefits and public benefits and weighing those. And so that inquiry is a factual inquiry and ultimately a factual decision by the trial court that there's public use and that there's no bad faith or there is bad faith. That too is a very factually intensive inquiry, and it's a factual conclusion, bad faith and public use.
Thank you.
Could I ask you, could you just point out then what were the disputed historical facts here?
Well, some of the facts were, was there bad faith or not? Was this initiated in bad faith? I mean, that is obvious. To me, that's an obvious factual dispute. There was no stipulation that there was bad faith or there was not bad faith.
And with regard to the question of public purpose?
A public purpose, well, the question was the condemnation for a public use or a private use, really? And that it was disputed by the parties, whether or not it was for private.
Was there a dispute about what it was for? Or is it just a debate over what constitutes a public use?
No, there was a debate about what it was for. Woodcrest alleged all along that this was undertaken solely to advance the subdivision process and to meet a requirement in an annexation agreement that the town of Parker required, that being that this parcel needed to be part of that subdivision. So Woodcrest all along said that was a private purpose. That was really the key purpose here. Whereas the petitioner, in this case, the Metro District, has repeatedly argued that this was done for a public purpose to put the public infrastructure into a subdivision within the town of Parker that was to connect to the surrounding area, put in roads, put in the utility lines, and that was the public purpose for the condemnation. And so that was always in dispute. It still is in dispute. And I think the Court of Appeals recognized that, the trial court recognized that.
So doesn't the Glenelg case suggest that it is a mixed question?
I think we have to focus really on the public purpose cases, which, I mean, Glenelg does have that general statement at the beginning of it that in condemnation, it's a mixed question of law and fact. In that case, it was a private way of necessity case, and they were determining whether or not whether or not this was a private way of necessity. It was a private condemnation. But ultimately, even in that case, they said that the issue of necessity, of whether or not this was a private way of necessity, was a question of fact, and the appellate court should defer to the trial court's findings. So that case, to me, it's sometimes hard to figure out why that initial question or initial statement by this court was it's a mixed question of law and fact, but ultimately by the end of the case, they really focused in on the factual inquiry of private way of necessity and found that you should defer to the trial court's findings on that particular fact.
So, did you have one on? If we adopt a de novo standard for the legal, if we disagree with you and decide that public use is a legal determination to be reviewed de novo after deferring to the findings of fact, do you still win? And if so, why? I assume your answer is yes.
Yes. So are you saying that if there would be a mixed question?
Mixed question, and ultimately we decide public use is a legal determination. Tell us how you win under that standard.
Well, I think a good example of when that happened was in the Knightsbridge case, the Sheridan redevelopment case. So in that case, it was a public use case, and this court, or not this court, I think it was the Court of Appeals, said that the trial court had got the public purpose test wrong. They'd used the necessity test, and so it was sent back to the trial court to use the correct test. And for the trial court to apply the standard, that legal test to the facts in that case. So in here, we have the right test that was applied. Nobody disputes that. And even the Court of Appeals says there was support in the record for the findings of the trial court of public use. But so I think we win anyways. I mean, there's even the Court of Appeals really kind of wove around that clear error standard somehow to try to open up the whole record just because it disagreed completely with the conclusions, really, and the factual conclusions of the trial court.
Yeah, I'm just trying to evaluate how dug in you need to be on the standard of review. It sounds like maybe not so much.
Well, I know, for example, that E470 versus 455 case, this court has set out this kind of analysis of mixed questions of law and fact, and that there's, I think, 3 different ways you can go with mixed questions of law and fact. You can almost do, if it's more factually intensive, you really look at it in an abuse of discretion type of standard or clear error standard. If the law and the facts are more mixed, it's a more mixed question. If it's really a legal inquiry, then it's more of a de novo standard of review. That was not a public use case. That was a motion limine evidentiary just within the context of just compensation. But that case kind of sets out, if you really wanted to go with that mixed question of law and fact, that even if you do that, in this situation, it's so factually intensive that you would probably fit in within that kind of clear error test of the different options of mixed questions of law and fact standard of review.
Thank you.
Ms. Bernstein, good afternoon. So on the public purpose issue, it seems to me that there are multiple purposes that are at least arguably were involved here. So why should we pick the purpose that you're advocating for? And why should we conclude in this particular case that the essential purpose was a public purpose?
Well, Your Honor, I don't think you, as the Supreme Court, should do that. I think, again, that is the trial court's determination. We sat through a day and a half of an evidentiary trial, witnesses on the stand. The Judge Cachette really asked questions of the witnesses, asked questions of us as counsel, and I think it's you don't have to go towards the facts of the case like apparently the Court of Appeals thought it could, because that was what the trial court did and weighed all of this evidence and weighed the alleged private benefits, weighed the public benefits, and looked at the different factors outlined in Shackley and made that determination based on that test.
I guess I'm more concerned about the application of the law to the facts.
Well, the law says that there can be incidental private benefits, right? And there's no arguing here that there were incidental private benefits here. But even if there is a private benefit, that doesn't defeat a public use determination. And there's plenty of cases out there where it seems to me that there is much more private benefits involved, but the court still says it's a public use. The Shackley case, where the public service company was simply condemning an easement for a utility line, electric line, to the Coors power plant, or the Coors factory in Golden, and that was all that line was serving. But the trial court went through the appropriate public use test and said, okay, we see there's private benefits, but there are some public benefits. Other members of the public can tap into this electric line. And the trial court found, yes, that's a public use, that meets the public use test. The Court of Appeals there reversed, but here at the Supreme Court, this court said that even though there was conflicting evidence on that, the trial court's findings were appropriate and they were clear, and the Court of Appeals was wrong in reversing that and adopted the clear error standard in that case, looking at those different weighing and approving of the trial court's weighing of all those different benefits alleged in that case.
I guess I'd like to hear, I understand what you just said, and I understand, if I were you, I'd be focusing on the standard myself, but I would like to hear what are the facts that support the essential purpose here was public?
The facts that supported the essential purpose was public was that this was a strip of land. It was about as wide as this courtroom, and it was about 400 feet long. And within that strip already was water lines, utility lines that connected different things around. So there already existed something in there that was public. And this development needed, as any development does in Colorado, public infrastructure. So the public infrastructure planned for this strip of land was a roadway to connect to all the other roadways in the town of Parker and Douglas County. There were utility lines associated with that development that were to connect with the broader community, and there was water and sanitation lines. And importantly, the town of Parker Water and Sanitation District supported this development and were requiring that those public uses were then dedicated to town of Parker and Water Sanitation District after the development was complete. I'd like to move on to the second issue on appeal, which is the question about whether or not a kind of final subdivision approval should be in place in order to condemn property, in order for a metro district to condemn property. And that was error. I think that should not happen, and it was error for the Court of Appeals to essentially state at the end of that opinion that the final plat wasn't approved, therefore the metro district doesn't have the ability or should not be able to condemn the property. They shouldn't be able to use their power of eminent domain until after a subdivision approval, a final subdivision approval is granted.
Do you read that as a conclusion as a matter of law as opposed to just one factor as to why it wasn't public? And with all respect, I guess when I read it, I read that more as it's a factor that they were looking at, but not a conclusion that you have to have all the permits in place.
Well, I think it heightens that specific fact. If that fact is in existence in other taking scenarios, then that could and maybe should, based on this case, prohibit a metro district from using its power of eminent domain. And really, since this case has come out, the Court of Appeals, metro districts are saying, we think we may need to have our subdivision approved and finalized and a final plat in order to condemn property, which really has tied their hands behind their back because a local jurisdiction is not going to approve the final plat without having the property that's part of the subdivision acquired by the Metro District or developer. So it has put in flux Metro District's ability to condemn property. And I think it was considered by the trial court, this fact, and I think it should be considered by the trial court as a fact, going to whether or not there's a public use and the stage of development. And it was here. The trial court really delved into what stage this development was in. And there was a lot of testimony about the fact that there was a preliminary plat approved, and the final plat was really just kind of a ministerial rubber stamp. But really, in order to get that rubber stamp on that final plat, this property had to be acquired, which is really understandable that the town of Parker required that, because they don't want to approve a subdivision and final plat until they get the property. And so this I guess, requirement that the Court of Appeals now has put in place, that a final plat must be in place in order for the Metro District to condemn, that is contrary to Colorado law that says that permits and approvals do not need to be in place before a property is condemned. And again, that Shackley case is a perfect example where the PUC had not yet approved the line that Public Service wanted to put in this easement, and the Supreme Court, or the trial court, and then the Supreme Court affirmed, said that's fine, that those permits and that permitting is not in place yet. The condemning authority can move forward with its condemnation. And I'd like to move on to
And I'm sorry, before you do, Ms.,
Okay.
and I'm sorry to hammer, I'm just troubled by the legal argument here. The Court of Appeals said in paragraph 36, I was looking for it, we acknowledge that a condemning entity is not required to obtain permits and approvals as a condition precedent to moving forward with condemnation. So, but you're arguing the opposite, that they held the opposite and we should reverse that.
Well, it's troubling. I mean, they acknowledge that law, but then they go on and say, they go on to say, I believe, I'll have to find it, but that here there was not a final plat.
Maybe the same paragraph, you know, they talk about could be no subdivision unless parcel C was acquired, et cetera. And they were just focusing on Cobobel and American Family Mutual Insurance.
Yes. What can what page are you on, Your Honor? I'm
Paragraph
sorry.
37.
Page
36
17.
and 37.
Page 17.
Page 17. Okay, paragraphs. I see it.
And I'm not quibbling
Yeah.
with their promise, I'm just trying to make sure I understand
it
where
is-
you're looking.
I know, and it is troubling. You know, the Court of Appeals made these statements of what the law really is, but then did not seem to follow it. And this was an example of the Court of Appeals saying that they're not required, but yet then making, you know, these approvals occur before the condemnation could happen.
I appreciate your clarification, thank you.
Sure. Okay, I'd like to move on to the statutory question here, and I think very clearly the Court of Appeals misapplied the statute here, 38-1-101-1B, which says that public use shall not include the taking of private property for transfer to a private entity for the purpose of economic development or enhancement of tax revenue. And here, there was never to be a transfer of this strip of property to a private entity. Always, this was going to be dedicated to the town of Parker and Parker Water and Sanitation District. So I think in this very clear and unambiguous statute, the Court of Appeals erred and applied this case, said that this case applied in this situation when there's never been any evidence there was going to be a transfer of this strip of property to a private entity. And I'd like to reserve the rest of my time.
You may.
Thank you.
Good afternoon. My name is David Schlachter. I'm with the firm of Diamond and Rager, and I represent Woodcrest Homes, the respondent in this case, and the landowner of the parcel of property that's being condemned. As I've thought about this case for this argument this morning, I was thinking, what's the essential question that you're being asked in all three of the issues that have been raised? And I think it's the question of whether or not the Colorado Constitution and the subsequent statutes permit a private party to use and to benefit from a public entity which has eminent domain powers to assemble land for a development for their private economic benefit. That's essentially what happened here. And I would like to obviously address the standard of review that's an issue for the court and talk about that first, and then I'll talk a little bit more about the public use and bad faith issues as well as the statute. Clearly, the determination of what is there a public use is a legal conclusion that any court, trial court, court of appeals, this court, has to make in applying and determining how does the Constitution and the statutes apply here. Likewise, pursuant to statute, determination of necessity is a legal issue, and actually even determining whether bad faith exists and thus negates public use and or necessity is a legal conclusion. That's what the case law and the Constitution and the statutes provide. And we acknowledge that there are facts that always need to be considered and the trial court needs to consider. That happens in every case of a mixed law and fact question. Those cases which use a clear error are either cases where there's not a mixed law and fact, or it's a case where where there are controverted facts and actually some kind of credibility or determination of which fact should be believed over another has to be made by the trial court. But that's not the case here. I know that opposing counsel has taken the position that there are controverted facts, but there's no historical facts presented to the court that were disputed by anyone. They're all the facts as, now the Court of Appeals laid those facts out much more clearly by reviewing the entire record than the district court did when it adopted the drafted opinion from the petitioner. But the fact is that those facts aren't disputed. We know exactly when and why and how everything happened here. And those facts aren't disputed, but how they get applied to the law is.
So, Mr. Schlachter, if I could ask about that. So what was the purpose of a two-day evidentiary hearing? I mean, if there are no facts disputed, you usually have a stipulation. I know, or my memory is you all didn't call your own witnesses, but you certainly cross-examined theirs vigorously. That suggests a fact question.
Well, there are certainly fact questions because the facts need to be known. Why were we not able to submit it by stipulation? You know, we tried. My sense is that maybe with more effort, counsel could have got there. But the reality is that the facts that are presented by the petitioner's own witnesses and the town's witnesses are the facts that the court had. Now, just because I cross-examine a witness and ask them to clarify their testimony doesn't mean their testimony is not credible or it isn't something that is undisputed. The facts are the facts, and we didn't put on contradictory evidence. So to come in and now say that somehow there has to be a deference to the district court, which in its opinion only has selected facts, not because it was making credibility issues, I would submit it's probably closer, although I don't think it's determinative in this case, what the Court of Appeals was troubled by under its heightened scrutiny analysis. It was those facts that the petitioner thought the district court should at least mention to most support the opinion they wanted entered. And that's what happened here. So it's appropriate for the Court of Appeals to look at those uncontroverted facts and say, now how do we apply them to the issue, to the legal questions? And that's what happened here. And that's where the de novo review is proper for the appellate court to take.
So talk to us about the public use piece. So why is opposing counsel wrong when she says that the public improvements that were contemplated for this otherwise seemingly useless strip of land makes this public use?
So the fact, I believe that the courts have been consistent in saying that the fact that there's an incidental or future public use doesn't equate to public use at the time that the condemnation is taken. You know, the fact that you put roads on a property in and of itself doesn't make it a public use. The question is what was the public use that was in place when the condemnation was commenced back in January of 2015? And there was no public use in place. There was not even, there is no evidence that there was even an approved subdivision. Now, there's evidence that you had a developer, I'm sorry.
No, please, finish your thought.
There was evidence that you had a developer seeking approval of a subdivision, and that they had actually entered an annexation agreement with the town, but the town said that there wouldn't be an approved development plan, that's the formal title for the subdivision, until all 3 parcels of land were consolidated by the developer. So the use that's in place at the condemnation filing is a private use. The developer needs to have an assemblage of land that he can come before the town and say, I have all 3 parcels under my control and ownership, and I'm ready to submit plans that lay out where I want to place my homes, my roads, my infrastructure within that complete 40 acres.
So opposing counsel, were you getting ready to? No, I'm sorry, I should have looked left before I. Opposing counsel says that you're getting the cart ahead of the horse, right? And what you're suggesting does seem counterintuitive to me, because it seems like most development would occur in more of a piecemeal fashion where you wouldn't necessarily have everything. You know, she talked about Shackley, for example. Can you respond to her argument in that respect?
Certainly. Shackley is distinguishable. In Shackley, you had public service already had the right and the ability to provide the utilities, whether it be electrical or gas, and it has the public use in place to provide that public property, and now it needs an easement to be able to serve Coors. And the question was, is it enough to serve only one party? And the court came back and said, that's okay, because everybody, all of the public, has the right to ask for the same thing. So it's a public use. Distinguish that from this case. In this case, the only party that had the ability to have an approved development plan with the town of Parker was the developer. It was only the developer who could acquire and assemble all 3 parcels, come before the town, say we've complied with our agreement, let us submit our plans and approve it. No one else could. It's not a question of whether or not there's a permit has to be issued. Now, once that development plan is approved because of the assemblage is complete, now there's permits, and it may be a different question at that point.
What if the district was formed first? That it wasn't the developer's initial agreement, it was the district's? Do we
So
have a problem?
If the district had formed before.
And then the
assemblage-
district did the agreement, the annexation agreement, whatever it was, with Parker. Can the district then go? It seems to be that your argument, well, I'm just wondering whether the argument is a timing issue.
I don't think it's just a timing issue. It's what is the public use? So we know from the undisputed facts that the developer has stated throughout in all of its preparation of the district documents that the reason for the district to be created so as it could finance future public developments that the developer is required to place on its development when it got approval from the town of Parker. And so the question is there a reason for a district to be formed before you even have an assemblage or even before you have a developer wanting to create an assemblage of land? My guess is there's not a reason. would the two landowners of A and B, two single landowners, go out and form a district to put in roads and utilities to serve their two houses? I don't think so. To me, that's an illogical assumption to think that districts are out there looking to create these public uses. They're not. They're a creation of the landowners that the district boundaries encompasses.
I'm trying to see if I'm tracking. So
Okay.
I understood the argument you made, and this is practical reality. But let's say, just hypothetically, the agreement here, your position is the developer created a district to get the land to satisfy its agreement. Let's say the agreement was with the district. For whatever reason, they figured, well, we're going to have condemnation issues. Let's form a district to kind of put all this together. The agreement was with the district. Could the district then go and acquire, condemn parcel C?
And the district, as in this case, is formed by the
Sure. And for the
developer?
same purpose. We're going to put roads on there and infrastructure and utilities.
That may be possible. I would submit that it would violate the bad faith criteria, the legal criteria, that it can't be taken as a pretext to declare a public use. That's basically what the bad faith does.
Where's the pretext? And I'm probably, I'm not quibbling. I'm trying to make sure I understand. I mean, it sounds to me undisputed that the purpose for parcel C was going to be utilities and infrastructure and roads. That sounds like the quintessential public purpose.
The facts were undisputed that the town of Parker required roads and infrastructure on the entire assembled property. The town of Parker did not say where the roads had to be. It did not demand that certain roads go in certain places. That was a developer's choice. And those choices were made looking at all 40 acres, all three parcels assembled as one. And therefore, this isn't a situation where you can simply say, because there's roads on parcel C, it must be public use. You have to ask, was it a public use when the project, the entire assembled project, came into being and was prepared to go forward?
Thank you.
When did Woodcrest acquire parcel C?
They acquired it very early on, like 2006.
And what was the purpose? What was Woodcrest intending to do?
They were intending to assemble three parcels of land. They realized there were two owners with the major parcels and the third one in between. So they bought the third one first and were under contract on the other three. So when they went to the town and signed an annexation agreement, they knew they owned all three parcels and could create the assemblage, which was the requirement for them to get an approved development plan.
But did Woodcrest have any plans for parcel C? What was going to be the plan for parcel C?
It was going to be part of the entire 40-acre parcel, assembled parcel, and it would have, the same types of houses, roads, infrastructure that the other 30-some acres, 39 acres would have, pursuant to their design of the development. But it wasn't mandated by the town how they used any one of the separate. It was just, you have to have so much density, to get so much density, you have to have so many roads, open space, infrastructure within your 40-acre assembled land. And so that was their plan.
I'm wondering if you can respond to the reply brief concern that upholding the Court of Appeals opinion here would wreak havoc with other developers, and the idea that developers routinely form these metropolitan districts for funding purposes, and that this opinion upsets that common practice.
I don't believe the Court of Appeals decision prevents any developer from properly forming a district to finance the improvements that they need to put in and that the developer needs to then see are dedicated to the town or whatever entity they're working with. What it does do is it prevents the developer from forming the district to create a private benefit for the developer.
So help me understand the distinction. Why is this situation different than the ordinary situation? What Woodcrest was planning to do had it been successful in acquiring the other two parcels?
Well, Woodcrest had been successful because they knew they needed all three parcels assembled. And so, because that was a requirement of the town of Parker. So they went and did that. Contrast that to the developer in this case. They got the two big parcels, but didn't want to complete negotiations and reach a, arm's length transaction with Woodcrest. Instead, they went and formed the district, which they probably were going to form the district anyway to at least finance. That's what their documents say. All of their documents say is the district will finance the public roadways and infrastructure. And then when they can't get a negotiated agreement, now they use the eminent domain powers of the district that they formed to finance to get what they can't get and satisfy the town's requirement for an assemblage. That's the error here, and that's what isn't permitted under the Constitution.
Well, let me ask you a kind of a version of Justice Gabriel's question. Let's assume they had formed the district before, and it was the district that was the party to the agreement with the town. Is there any problem with the district in that situation exercising eminent domain to obtain parcel C?
So let me make sure I understand your question. So if the district, as a district, had went to the town and said, we want an assemblage that we can have an approved development property on, will you let us do that? We're a district, so we're going to go out and condemn the three lands that we want? No, I don't believe that's permissible. The district, to me, that's just counterintuitive. If that were the case, every developer would create a district, go out and have that district condemn its identified parcels, create its assemblage, and then move forward. And that's not what the Constitution says. It's very clear that private parties, and the district isn't the developer, they're not going to build the houses, they're not going to sell the houses, it's the developer. And the developer, as a private party, isn't permitted to take another private party's property if it isn't permitted under the express terms of the Constitution. I'm not sure if I've answered your question
Thank you, I
adequately,
appreciate that.
but-
So can I ask, this is sort of to the side, but I don't think necessarily irrelevant. What did Woodcrest, before the Court of Appeals opinion, under the exercise of eminent domain, did Woodcrest receive fair market value for the land as part of the exercise?
As part of, it received an award from a group of commissioners. Now, that award is sitting in the registry of the court because it's been appealed. Our contention isn't the valuation. Our contention is that they never had a right of eminent domain to start with.
But they would, as part of eminent domain, get a fair market value for that land.
Fair market value as determined by a panel of commissioners, yes. I've got about 2 minutes, so let me quick shift to the statute. So the statute doesn't limit the amended provisions to only situations where there's urban renewal. It says, if you have a private, let me get my language clear in front of me here. It says that you can't have eminent domain or a taking of private property where that private property is for private economic development or where it enhances tax revenue. And
That's not quite what it says. It says for transfer to a private entity for the purpose.
Right.
Where's the transfer to a private entity here?
So it says as when it's transferred. And here, in this case, our argument is that, and I think the Court of Appeals realized this by looking at the record and applying it to the law, is that the transfer effectively does happen. Because what happens here is the developer and the town reach an agreement that says, district, you may now come in and you can assemble the land by condemning C on behalf of the developers, in essence, and now you can dedicate the land to the town. And so they've basically simply put the district in place of the developer to skirt that provision that says you can't transfer and where it's going to create an economic benefit or tax enhancement. So I acknowledge that it doesn't fit the exact language, but the clear intent of the statute is that you can't allow a public entity to act on behalf of a private entity for the private entity's benefit. And that's what essentially happened in this case, and will happen if the court does not, will happen if the Court of Appeals isn't affirmed.
Thank you.
Good morning, Your Honors. May it please the Court. I'm Jeffrey Redfern, here on behalf of the Institute for Justice. The petitioner today is essentially asking this Court to adopt a rule whereby courts would have to treat the stated purpose of a condemnation as conclusive without inquiry into the actual purpose. No court has ever held that. This Court rejected that argument in Block 173. The Supreme Court in Kelo likewise held that pretextual takings are unconstitutional. And it doesn't matter if the stated purpose is a road, and if that road will in fact be built. That was the issue in the C&J Coop case from Hawaii. The Supreme Court there squarely rejected the argument that the pretext inquiry doesn't apply when the stated purpose is a so-called classic purpose, like a road. So this rule about pretextual takings is well established around the country. And while there's no exclusive list of factors that are necessary to prove pretext, there are certain factors that have come up again and again when courts have found it. And I think that 3 of them are particularly relevant in this case. One is the existence of a known private beneficiary for the taking. Another is that this taking was not done pursuant to a carefully considered long-term government plan. And third are the irregular and suspicious circumstances, procedures surrounding the taking. So as the Court noted in Kelo, the risk of a pretextual taking is highest when there's a known private beneficiary. And courts have struck down takings when the government is essentially acting at the behest of a private party. That happened in the 99-cent stores case from California and also in the New Jersey casino case. Now here, the situation is actually much worse because we don't just have a cozy relationship between the developer and the district. The district is the developer's alter ego under its complete control, and that isn't really contested. So condemnations like this just don't happen outside of Colorado. In fact, in the C&J Coop case, there's a passage towards the end of the majority's opinion where the majority criticizes the dissent, saying, well, if we take your argument to its logical conclusion, that would allow for the delegation of eminent domain authority to private parties so long as they're building roads. And the majority thought that was obviously unconstitutional, obviously beyond the pale, but it's exactly what's happening here in Colorado.
But doesn't the Special District Act essentially allow that?
Well, the Special District...
There's no challenge here to the constitutionality of the Special District Act.
No, there isn't.
And the developers can create these districts. So I'm worried about the limitations of your argument, that to suggest that because there's a developer behind a district, therefore there's an alter ego situation, and therefore anytime you have a taking, it's pretextual because it ultimately might benefit that developer.
Well, I don't think that either the Special District Act or the delegation of eminent domain authority are facially unconstitutional, but I do think that the Fifth Amendment limits the circumstances in which condemnation can occur. And yes, I think that when a special district is under the control of a single developer, it's hard to see how it's going to satisfy the public use test. But I don't think that that is really a huge problem. The primary purpose of special districts are as a financing tool, and they'll remain financing tools. And in every other state in the country, there's no comparable mechanism where private developers can just create a quasi-governmental entity and then direct it to condemn property for its own benefit. Yet development happens everywhere else without problems. Another issue here is that there's a lack of a long-term government-created plan. That was a key factor in Kelo, where the court upheld the taking. The courts have frequently found that the absence of such a plan demonstrates pretext. That happened in the Lands of Stone case from the Pennsylvania Supreme Court, Earth Management from the Georgia Supreme Court, Pheasant Ridge out of Massachusetts, and in the recent New Hampshire case that we submitted as supplemental authority. In this case, the only long-term, carefully considered plan is the developers. But we can't impute that plan to the government because the whole point of the inquiry is to distinguish public from private purposes. The final factor that I'd like to
I'm sorry,
address.
may I ask Mr. Redfern on that? What do we do with the annexation agreement? First with Woodcrest and now with the developer here. Is that not evidence of a long-term plan?
2 points, Your
But
Honor.
Parker, this is Parker. This town was involved.
2 points. One is that the town of Parker doesn't have a long-term plan. It has an agreement, but that agreement is not the kind of carefully considered, comprehensive look at what's going to happen here that the developer's been doing. It's essentially just saying if you get all of this land together and get the necessary public improvements, we'll annex you. But that's not the town of Parker's plan. And moreover, the town of Parker has expressly declined to exercise eminent domain. So they're not the ones who are asserting that there's a public purpose or necessity here.
So what is required to evidence a long-term plan that you say is required? Does it have to be a development plan between the town and a developer? Or what does that look like?
It could be something like that. If the town had wanted a particular development here and had a particular idea of what it was looking for, and it was looking for developers for this, that would be a very different situation from what we have here, where the developer comes up with the plan itself and then just asks the town to go along with it. The final factor I'd like to talk about is the procedural irregularity of the taking in this case. Courts have repeatedly held that takings are pretextual when the taking happened pursuant to an unusual or suspicious procedure. That happened in Rhode Island parking, in the Armendariz case from the Ninth Circuit, and in the cases I mentioned previously, Lands of Stone, Earth Management, and Pheasant Ridge. In this case, the procedures really are quite troubling. We have a district that consists of 3 parcels. The owner of 2 of those parcels threatens eminent domain against the owner of the other parcel before a district even existed. Then it creates a district, staffs it with its own employees through the use of sham option contracts, and directs them to take the third party's property. Now, that procedure, to the extent we can call it that, is really just the proverbial 2 wolves and a sheep voting on what's for dinner. So I think we can look at this case through a lot of different lenses that courts around the country have used. And no matter how we look at it, it comes out looking more egregious than cases where courts have found pretext. The purpose of this condemnation was to serve the developer's private interests. It doesn't matter if a road will in fact be built and if the public will in fact drive on it. The whole point of the pretext inquiry is that the primary purpose matters, not whether or not the public eventually uses the land. Satisfying a private contractual agreement, as the Goodner case held, is not a public purpose. That case has been accepted for 30 years in Colorado and cited with approval by this court. I think the rule is correct, and there's no reason to depart from it here. And I just want to emphasize one more time, because I think there's some concern here, that this is a unique situation in Colorado. There is no other place where private parties create governmental entities and condemn land for their own benefit.
But you're saying that what happens in Colorado is unique, not that this is unique and doesn't happen in Colorado.
Right.
Okay.
Sorry.
So again, so it seems like your concern is with the Special District Act.
Well, no, I think the Special District Act has a real purpose, and it will continue to do so as a financing tool, and that when a special district is not under the exclusive control of a single developer, then it might frequently be able to use eminent domain in a way that satisfies public use. But when it is essentially just an organ of a private for-profit entity, I don't see how it could survive this pretext inquiry that is well accepted around the country and is accepted in Colorado, frankly.
So is there anything in the Special District Act that prevents a developer from basically having its own folks be part of the board of the district?
No, they're required to disclose conflicts of interest. I think it probably is assumed that when a district is formed and land is undeveloped entirely and there are no residents, that developers probably will have control. But I think that the Fifth Amendment's limitations on pretextual takings are the important limitation here, regardless of what the Special District Act says. And it's not a facial challenge to the Special District Act. It's just saying that under some circumstances, there isn't going to be a constitutional way for a special district to exercise eminent domain. And that's the way it is in the rest of the country, and development happens in the rest of the country just fine. If there are no further questions, I would just say that ruling for the petitioner here would take Colorado radically out of step with eminent domain law in the rest of the country, and we would ask that the court affirm.
Thank you very much. Ms. Bernstein?
Thank you. I think what you heard from, both in the Court of Appeals opinion and from the opposing counsel here and the Institute for Justice, is really this underlying suspicion, right, that the Metro District here was formed for some sort of improper purpose. And really, it's calls into question really the Special District Act in general and the legislature's granting of the power of eminent domain to metro districts. But that issue is not before the court. That's what our statute allows. That's how development occurs in Colorado. It may not happen in the rest of the country, but in Colorado, that is a primary tool for development. It's the creation of metro districts by developers that are initially controlled by developers. And with that, the legislature granted the power of eminent domain. And that power of eminent domain, too, is not to allow a metro district to condemn property for any purposes at all. It is limited to roadway improvements, water and sanitation, and sewer and utility lines and fire protection.
Can you address on that point, Ms. Bernstein, the argument from your friends across the aisle that here there was no stipulation that parcel C was going to be for those purposes? Just you got to put all three together, and then the developer decided what it was going to do. So they say no public purpose here for that reason. Could you address that?
It was always planned that within this strip of property, there would only be public improvements and public infrastructure.
And based on what? Where in the record is that? Where do we look to see that?
It's
not a page. I mean, is
Yeah.
it a document or what?
It's replete throughout the record, and I think Exhibit 3 is a demonstrative exhibit that just shows within the strip what is planned and what is existing. So you'll see a bunch of lines that are blue and red, and some say existing and some say planned, and then the roadway within there as well. And importantly, I think Justice Moore, you asked the question, what did Woodcrest intend to do with this strip? There's an exhibit presented at the trial court of Woodcrest's plans for what was to be put in this strip. It was the same. It was the roadway, it was the utility lines, and that was because there was an existing utility line through there already, and it was kind of a natural drainage area. Always the plans were for the public infrastructure to be put within this strip.
Can I ask a similar question? If instead of owning the two side properties, if you owned A and C, could you have condemned B?
No. Not if you could condemn B. You could condemn maybe a little part of B if there was a utility easement needed through there.
Limited to where you would put public?
Exactly. The 32.1.1004 subsection 4 lists the purposes that a metro district can condemn for. It outlines it, and this happens with any condemning authority. There are specific limitations, and this here it was for fire protection, roadway improvements, and utility lines. They couldn't condemn it for a park. They can't condemn it for a house. It's limited. So if there needed to be, if they needed to acquire other property within the development, it would be limited to just those within that list of uses.
Right, thank you.
Can I follow up on these, and also on Justice Gabriel's question? From your response to him, it seems to me you seem to agree that if the developer could simply decide now with the 3 pieces of property where to put the utility lines, that would not be, you would not meet the public purpose requirement. I guess what I haven't, is that not right?
No, I'm trying to understand your question, meaning if the plans weren't there in place yet or for some reason.
Right, or if it were clearly the case, if you admitted you condemned parcel C and afterwards the developer would decide where to put the utility
That
lines.
was not okay.
Right, so
Yeah, I mean, that just wasn't the yeah.
So I guess where I was going with that was, you had a little, I thought there was a little question about how your purpose is evidenced here, how definitively that is. And I was going to ask you, as a broad question for the type of thing that you're doing, what would be enough to indicate that is your purpose for condemning this land? And closely related to that, how bound would you be to use the land for that purpose?
So once, let me start from the end of your question. So once the Metro District condemns a property, has title to it, is then the Metro District bound to use it for those purposes?
That's the last part of my question. I guess the first
I
part
mean-
is how much, what is required to evidence that's your purpose?
You don't have to go back to the court and say, look, we did what we say we were going to do. You don't have to do that. Once title passes, which happens at the conclusion of the valuation proceeding, then the Metro District owns it. I've never been, I mean, I've done this for a long time. I've never been involved with a case that someone says, okay, you put something else there that you said you weren't going to put there. It doesn't seem to
And with
come up.
regard to the first half, that is your purpose, is a representation to the court, is that what is required? You don't
That's
have
what's
to
required.
Show them plans that you've got for laying those roads or anything?
And yes, and that's what's required, and that was what was presented here, were those plans. And the town of Parker, importantly, I mean, they are approving those plans as laid out, and it would have to go through a very different process to make changes to those plans. You probably have to go back to a hearing process in order to get those plans
Fine,
changed.
thank you.
And does Judge Cachette's factual findings include those facts on which you rely for public purpose?
They do. It's a 24-page order replete with, factual findings, cites to the records, the exhibits. It's very detailed. I think that's my time. I would ask this court to reverse the trial court and to reinstate reverse the Court of Appeals and to reinstate the trial court order granting possession. Thank you, Your Honors.
Thank you. Appreciate the arguments of both sets of counsel, and the case will stand submitted, and the court's going to be in recess for 15 minutes. Thank you. Please be seated. Next case on our afternoon docket is captioned Rail v. People. We've set it for an hour. Y'all are both old timers. Please begin your argument when you're ready.
And Emma Corella representing the petitioner Paul Rail. Mr. Chief Justice, and may it please the court agreed to hear two issues today. They are related. One involves a substantive claim that Mr. Rail raised in the Court of Appeals concerning Mr. Rail's constitutional rights to due process, including the right to a jury verdict of guilt as to each and every element of a charged offense, and also the right to have the jury rather than the judge reach the requisite finding of guilty. The Court of Appeals declined to review this claim, saying that it had been waived. And that is the other issue that this court has agreed to hear. And because that's the hurdle I have to get over, I'll start with waiver today. And if you don't mind, I'll just give a small summary of the facts, because I think they're all fresh on our minds, and they're very pertinent to both of the issues. I'm going to focus on the charges related to the minor BH, because the minor CH, all of the charges there were acquittals. As to BH, Mr. Rail was charged with sexual assault on a child and sexual assault on a child position of trust, and then an enhancer sexual assault on a child pattern. After BH's testimony and before the jury went to deliberate, they included in the instructions a unanimity interrogatory for the SAOC charge. They also included, which is fairly standard for the SAOC pattern charge, they included interrogatories as to the acts that were committed. And the interrogatories were virtually the same, except for the SAOC pattern interrogatory had one additional act that was outside the charging timeframe. The jury returned with their verdicts. They gave them to the bailiff gave them to the judge. The judge read out loud that Mr. Rail there was a general verdict of guilty as to the SAOC charge. There was an acquittal on the SAOC POT, and that the jury had found that the pattern interrogatories had been proved. There was, unfortunately, one verdict, the unanimity interrogatory, I should say the findings as to the acts that were to support the general verdict of guilt on the SAOC charge were never read aloud. And those findings indicated that the jury unanimously found that none of the acts had been proved that were to support the SAOC charge. When the court announced read what it did read, it pulled the jury, it sua sponte pulled the jury itself. Are these your verdicts? They all said yes.
Counsel, why do you think the court pulled the jury?
I think that's fairly standard. I think that happens in most of the cases that I see, that there's a polling component. I don't know beyond that. There was no indication of something that the court was worried about or anything like that. There's nothing like that in the record. So the jury was polled. Then the judge turned to counsel and said, do you want any further polling? Both counsels said no. So with this set of facts, when we got to the Court of Appeals with this claim involving the unanimity interrogatory failing to support the general verdict of guilt on the SAOC charge, that was raised as a claim.
Ms. Emmerich, can I just ask you about a factual question before you go on? Before the jury was dismissed, did either counsel, either prosecutor or defense counsel, get a chance to look at the verdict forms?
No, That's not in the record. There's no indication that anybody went beyond the bar or that the bailiff brought anything to counsel or anything like that. It went directly to the court. The court read them, and then it accepted the verdicts.
Right.
So in the Court of Appeals, fairly quickly the Court of Appeals said, well, we obviously embraced Sanchez, this court's opinion in Sanchez, and the Court of Appeals said, no, here you have a guilty verdict, so we're not going there with you. And they went ahead and said they really focused on a variety of other areas of law, inconsistent verdicts and polling and things like that. And ultimately, I think what they said tipped the scales for it was their own opinion, the Court of Appeals' opinion in Rediger, because counsel and this notion of affirmative acquiescence, that by not asking to have further polling, counsel affirmatively gave up this opportunity to hear what the jury findings were on that unanimity interrogatory. And I wanted to sort of focus on Rediger since perhaps the landscape of waiver has been clarified, since Mr. Rail's case in the Court of Appeals obviously predated this court's opinion in Rediger. And Rediger embraces Olano and makes very clear that waiver is an intentional relinquishment or abandonment of a known right or privilege. There's no, and in Mr. Rediger's case, the court looked for evidence, either express or implied, that Rediger intended to relinquish his right to be tried in conformity with the charges in the charging document, and there was no unequivocal act indicative of waiver. And I would argue that is the same situation here. There's no indication that some type of strategy was involved. I know that the Court of Appeals opinion suggests there are a variety of scenarios that could have gone through defense counsel's head, and that two of the options were unfavorable, one was favorable, but that all happened very quickly, and it's hard to imagine really what would have been gained by that, what was strategic about that moment in time when counsel did not know that these interrogatories said what they said. The other thing that the concurrence in that case relied upon, and that the Attorney General also relies upon, is this notion that what occurred here is equivalent to what occurred in the Stackhouse case, where there was a known closure of the courtroom, and so this constitutional right to public trial was violated. And I would just submit that there was no known anything waived here. There was no defense counsel, unlike the counsel in Stackhouse, did not know that these unanimity interrogatories were traveling away, and that there was something for him to say, right? Which is a lot of these inconsistent verdict cases, or cases where there's some discrepancy in the verdict forms. There's, by and large, this opportunity where everybody knows that, oh, there's this issue, and then there's a discussion about it, or counsel is very aware of what the issue is. And that is simply not the case here, where defense counsel, there's no indication that defense counsel had any understanding of what had occurred. And it seems highly unlikely that he would, because Mr. Rail was facing under the pattern count a mandatory prison term, that he would think, well, I'm going to sit on the possibility that I didn't hear something that was favorable to me while Mr. Rail goes off to prison, and we resolve this in the land of appeals. So in my mind, it seems fairly obvious that there was no waiver here in the way that we've come to think of waiver in Rediger. And if the court has any questions about that, I'm happy to answer them, because I certainly don't want to leave a waiver stone unturned here so that we don't get to the merits and I haven't addressed something that you don't want to address. Okay, then I will move on to the merits question.
Could you address the standard of review before you get there? Let's assume for arguments, I know you've argued structural error in Sanchez. Let's just assume for argument's sake we don't agree to that. What is there? Is it a plain error review, or what's the standard?
Yeah, I think I've argued that that it seems odd to say here's this structural error and this thing that counsel never had the opportunity to object to, and somehow that's not structural error because it involves this right that's actually very personal to Mr. Rail, which is this right to a jury verdict that he would normally have to waive knowingly, voluntarily, and intelligently, and none of that occurred here. But I think that even without, because I understand in Sanchez there was this understanding of what had occurred, and that is obviously not on the record here. So,
well, the other distinction, I think, in Sanchez was we had a verdict form that said not guilty.
yeah, correct. But and so we are. This is not as straightforward as Sanchez, but it's definitely problematic because we also have an interrogatory meant to support the guilty verdict that simply says the acts weren't proved. So I think, yes, plain error. I mean, this is not a situation, and I'm very mindful of Justice Marquez's dissent in Stackhouse where, you know, if we have something that's structural error, it doesn't necessarily mean if there's no objection that we can't move on to plain error. I think we can. I think the case is talking about that when they say that structural error may defy a kind of harmless error analysis doesn't equate to saying that you can't apply the prongs of a plain error and find that something was so fundamentally unfair that it, you know, it undermined the verdicts in the case. So I can definitely go to plain error with you if you want. In terms of the merits.
So let me just put a period on that sentence. And I cut you off on structural, and I didn't mean to. I was just curious if we got past there, where we go. So your argument is first, this was structural error.
Yeah, I think
and
it is
alternatively
structural
plain
error.
error.
It's this weird wrinkle, Justice Gabriel, where I do think it's odd that there is no opportunity to object to this error, really, no real opportunity to do that, nothing strategic really happening. And then you say, well, you missed that boat, and now we're going to apply plain error. But I realize that we don't have a Supreme Court case, and the U.S. Supreme Court doesn't have a case sort of saying that structural error always equates to fulfillment of that third prong of plain error. But I think we clearly meet it here.
Yes, my question on the tail end of this is, so if there was never an opportunity to object, where's the default? Why aren't you just arguing harmless error as your alternative to structural error?
Well, I guess, I mean, I essentially, you mean, I guess I don't understand your question.
Why would we then move to plain error? Maybe I'm missing something here. You're not, I take it the way you phrased this, you feel there was no default here. There was no opportunity to object.
Correct. Yes.
So we don't have a failure to object. Are you just arguing there is
true.
error?
Yes,
there is just
absolutely.
trial error?
Yeah, right, absolutely, absolutely. I embrace that idea, yes. And obviously I tried to show you all the comparisons between Sanchez and Mr. Rail's case, and I agree, it's not quite as straightforward, but there's this unanimity interrogatory, and I understand there's a pattern interrogatory over here. We don't have a separate, the pattern interrogatory is meant to support an enhancer. It is not a substantive count. And That's what the jury understood it to be, I think, and that's what the jury instructions make clear. And so you can't just, the way the Court of Appeals seemed to do, substitute in the pattern interrogatory for the unanimity interrogatory and kind of pretend like the unanimity interrogatory never existed.
What about the polling the jury for unanimity? Can you substitute that in?
I think you can, Justice Hart, because this jury, again, it's a jury being asked by a judge, according to the following things that I've read to you. Is that accurate? Yes, it was accurate. But they don't know why he didn't read aloud this other thing. I don't think they can fully comprehend what that means at all. And I think one of the cases that I cited in my briefing talks about the jury needs to be given an opportunity to then say, oh, yes, we also said that too. And for there to be a moment for them to articulate, yeah, no, we believe this, and we believe this, and we believe this, and we believe this. So there's this notion of sort of implied polling as to something that wasn't read, I don't think works.
But the jury couldn't believe both here, right? I mean, the jury could not believe both, that each incident had been proven and that each incident had not been proven. And so if the judge asks each juror about one of those findings and says, is this and was this your verdict? And they say yes. Why isn't that sufficient for us to rely on?
It's not sufficient, Justice Moore, because we have this other verdict out there where he didn't ask them about, is this also your finding? Are you finding it's not proved? And additionally, those findings were associated with the pattern. They weren't associated with the substantive offense. And so without asking them, what do these other interrogatories mean? Asking them about one set doesn't really have meaning. It just means you've elected to ask them about one set. And so I think some of the briefing talks about, and it might be then Judge Gorsuch's opinion, where he's dealing with that Shipley case, where the court saw that. You know, you had the substantive charge on the drug offense, the conspiracy offense, and you had the interrogatory as to amount, and the jury came back with something completely, like, no, there was no amount, there was nothing, and he lays out why. Yes, you both are not true at the same time, but that is not a guilty verdict.
Let's assume for a moment that the jury, as to each incident, made one finding, either proven or not proven, okay? Let's just assume in a hypothetical.
Okay.
And the judge asks them about one of those, and they agree, and they say, yes, that's what our finding is. Why isn't that reliable? I mean, I understand that they may have filled out, and by the way, I'm assuming you agree that these verdict forms were confusing.
Yes, I agree.
So, and I can see, for example, on the problematic verdict form, how they might have understood that to relate only to the positional trust count, which of course they found not guilty on. But it's one finding, only one finding is possible as to each particular incident. And so if the judge had asked, for example, let's say that the judge had asked in the hypothetical the opposite, hey, I'm reading here, and is this or was this your verdict? You did not find this incident proven. If they've made one finding and that's their finding, then we'd expect them to say, yes, that's correct, that's our verdict. On the other hand, if that's wrong, we'd expect each juror to say, no, Judge, that's wrong, right? Why isn't that reliable?
I think it's not reliable because, again, they have been asked to support they are asked for a general verdict of guilt. The reason why we're grappling with this is actually the reason why we can't assign a verdict to this case. We actually don't know what the jury decided because we're having to sort of speculate, well, why did they do this and why didn't they do that? Why did they? I don't think we don't get to take an actual answer that the jury provides and put it aside and say, well, this part doesn't count because it makes the other part not make sense. I don't think you get to do that. And Sanchez very explicitly tells us that we cannot have a verdict that rests upon something that's ambiguous to us.
But as Justice Gabriel said, that's distinguishable, right? That situation in Sanchez is not what we have here, correct?
I think, I don't know if that was Justice Gabriel's point, but I think that it is what we have here, and that's what I'm arguing. Because what is the point of a unanimity interrogatory if it's not meant to support the verdict? And so that's what we have. And we have this internal inconsistency in the verdict. What the Constitution tells us is that we can't then say, well, we should, ignore this part and just look at this part, and they answered this once in a way that supports this, and so we should just put this part aside and pretend like it never happened, because it did. I mean, I think, again, Judge Gorsuch dealt with this in that Shipley case and said, you can't choose whose ox to gore. That's the jury's job.
But with respect to the unanimity instruction, it applied both to the sex assault on a child and the sex assault position of trust.
Correct.
Right? And I think I'm dovetailing on perhaps one of Justice Samore's questions, but even without putting it to one side, just trying to make sense of what the jury did here, seems reasonable to think that having found the defendant not guilty on the position of trust, that it associated this unanimity interrogatory with that not guilty finding.
Mm-hmm. And I think, again, that is in complete defiance of the jury instructions, which they managed to follow in every other way. And it is us crafting an explanation.
Well, is that entirely true? I mean, what I think very well could have thrown them off is the way that it's captioned, right? The unanimity interrogatory actually refers in its caption to the POT. And so the interrogatory goes on to say other things, right? And so it seems reasonable to infer, given the other verdict forms, that they thought that they were just amplifying on their POT verdict.
Right, and I think, but then as we assume that the jury reads the instructions, not just the caption, that they understood what this was. And in fact, the court a little bit tripped over this when he was reading the jury instructions aloud to them. And then he went back and he corrected himself. And he said, no, this applies to both.
Right, why? And that's the part where the judge got confused, I think. Why would you have them fill this out twice?
Because one is a unit.
The instructions specifically tell them, if you find the defendant guilty either of sexual assault on a child or sexual assault on a child by a person in a position of trust, answer this interrogatory. And then separately, he's asking about the same incidents plus one on the sexual assault on a child special interrogatory. It doesn't make sense to ask the same question twice.
Well, I think you have to support when you have acts like this, that a child has testified to 20 or 25 acts and they're not all the same, and you have to support the guilty verdict, which the court has agreed that should happen, or the court has said this should happen, they should fill this out, they should complete this and tell us what acts they unanimously agreed to as a constitutional matter. And then you must do the same thing in order to find that the jury has to unanimously agree that 2 or more acts of sexual contact occurred in the pattern count. You kind of can't not ask them both times. That's my position on that.
Ultimately, you seem to be saying that any ambiguity with respect to the verdict that's created by the unanimity interrogatory has to be resolved in favor of the defendant here. I've been struggling with what to do with the inference that I just shared with you. I looked at that from the first moment I looked at it. I thought, oh, I see what they did. Mm-hmm. And maybe I'm right, maybe I'm wrong. I feel very confident that that's probably what happened, but what am I allowed to do with my inference? And you're telling me because you're making an inference, well, you shouldn't be making an inference, right?
Correct.
Right, and that's the bottom line.
Right. We don't have guilt by inference, right?
Right.
Correct.
Can
Yes.
I pick up on something you said about constitutional and, have we ever even held that this kind of an instruction is required? That the jury, this looks a little bit like a civil version of a general verdict with
Yeah.
interrogatories to test the verdict. I know we've said, Thomas, and that whole line of cases, that the jury has to either agree on the same act or that all the acts occurred. But have we ever said they have to specify which acts they agree on and which they don't?
I think by virtue of the fact, I'm thinking of cases like Astorga and Kogan and things like that, that is one way of ensuring it. And once that ship sails and goes to the jury, that's what happens. That's what they've got. I think Colorado requires unanimity, right? As to and I know there's some dispute about like how far do we go with that, but there is unanimity as to each element. Yes.
Absolutely.
Okay.
But, and I guess what I'm asking about is these findings, and part of the reason I'm asking that is picking up a little on what I take to be part of your opponent's argument, and that is, if it really is in the nature, even if it didn't have to be given, if it is given in a way of testing whether they really found these particular acts in their verdict of guilt, how is that not what we've decided is an inconsistent verdict in Fry and such, and doesn't call for
Well, sure,
reversal?
and I would be happy, and I'm mindful of my time here, but I would be happy to say that this is an acquittal and a guilty verdict, because the acquittal is on the substantive offense and the guilty is on the enhancer, and you can't have an enhancer to an acquitted offense like that. And in terms of inconsistent verdicts, if we're comparing them in some other way, like there's a guilty verdict and a guilty verdict on the substantive offense and a guilty verdict on this enhancer, they're completely mutually exclusive. I mean, Fry tells us that doesn't work. We can't just pick one or the other. Again, we're choosing whose ox is to be gored. And what we should do then is just send it back and have another jury figure out what, do it right.
So with regard to the Fry type of argument, you'd be saying what happened here, these findings really do amount to finding something did happen and it didn't happen?
Well, I would say that that's kind of the Fry argument, right? That's the Powell argument. That's the, we can't compare an acquittal, right? If a jury comes back with a substantive acquittal on a substantive offense and it comes back with a guilty verdict on another substantive offense, and they're not the same elements, we say, well, that's, lenity. We don't try to figure out what the jury was doing. They were doing something, and clearly they had their own conclusion about this. But there's no lenity here. We have just a guilty verdict. And so that's my problem with that particular argument. And if the court doesn't mind, I would like to reserve the rest of my time for rebuttal. Thank you.
John Lee, on behalf of the people, bar number 38141. Thank you, and may it please the court. Counsel begun with discussing one hurdle the defense would need to overcome. I'd like to borrow on that framework and add 3 more. In order to overturn the Court of Appeals in this case, defense counsel would have to show that 1, there was in fact a unanimity problem in this case, 2, that it's reviewable, 3, that it's theoretically reversible under Sanchez, and 4, that any error was not harmless given the jury's subsequent polling. I'd like to begin on the first issue because whether or not there was a unanimity problem in this case would moot the issues, and to the extent this court falls short of finding that, depending on how this court characterizes the claim, that's going to form the linchpin for the other 3 issues. Justice Coates addressed the question of whether or not the interrogatory was actually necessary. as Justice Coates explained, this court has found that an additional interrogatory can be useful in ensuring unanimity. It has never gone quite so far to say that it is required. But even assuming under defense counsel's framework that it is necessary, they fail their own test. Defense counsel cites Thomas for the proposition that in some cases, when you have multiple acts, any one of which could satisfy the charged offense, a unanimity instruction might be required. One way to ensure unanimity is through a special interrogatory. We had that here. They found him guilty on the pattern interrogatory. The other way, and this is the way that this court described in Thomas, is to provide a unanimity instruction, which is to instruct the jury that to find the defendant guilty on the verdict form, they must all agree that the defendant committed the same act, the same set of acts, or all of the acts. The court gave the jury that unanimity instruction in this case. That's instruction 14 on page 134 of the record. So in this case, the challenged interrogatory wasn't even necessary to the child sex assault count because they were given the actual unanimity instruction in instruction 14.
But can we just ignore the fact that they
Yeah.
signed one that said not proved, not proved, not proved, and not proved?
Right, so maybe they didn't have to do it. The trial court didn't have to do it, right? But the fact is the court did, and so we're stuck with this, as Justice Gabriel's asking.
Well, so I'd say legally it wasn't necessary, so it's overkill. So to the extent, unanimity only requires that the jury unanimously find the defendant guilty under the instructions as given. And in this case, I think looking at the first verdict alone, coupled with instruction 14, that's enough.
But you're ignoring the fact that we have on the very count, SAOC, we have a verdict form that says guilty and interrogatories that are checked 4 times, all 4 instances not proved. Why isn't that the same issue as in Shipley, that we don't have a valid verdict?
So I'd say 3 responses. So one, I do think legally in Shipley, the issue was there was not, the instructions is given a complete unanimous verdict as to all the elements of the offense. I mean, in this case, there is, again, when you look at instruction 14 with the general verdict. So that would be my first answer. My second answer would be that in this case, we also have the pattern interrogatory where they did find all those items proved.
But if they didn't convict on the SAOC, you never get to pattern. And so how do we take the pattern ones and apply them to the SAOC if, in fact, it was a not guilty verdict? We never get to the pattern. I mean, the problem was we've got internal, you can't have both, as several of my colleagues said, Justice Samore said at the same time. And my concern is, had it been read, the defendant could have said, whoa, we have a problem. But it wasn't.
So I guess my first answer would be there is no problem because they're not in conflict. And as we argued in the brief, and let me put it kind of in context with, and this court's kind of already discussed it, whether or not how the jury actually would have interpreted these verdicts. Because I think logically and literally, it's not, the 2 verdicts aren't in conflict. So when the court gave these instructions, they were given side by side. So the first verdict form was the sex assault. The next one was the pattern. The third then came the interrogatory on the pattern of abuse. And then the fourth one was the challenge interrogatory where they found the incidents were not proved. I think given that sequence, it made sense that the jury looked at this interrogatory, the third one, went with the child sex assault, which they already completed, and then when they then went to the position of trust, that went with the other following interrogatory.
But why do we infer that here? I mean, we got 100 cases, I probably heard you argue a bunch of times. We presume the jury followed the instructions. The interrogatories on the SCOC said, we, the jury, having found guilty of SCOC or SCOC position of trust, you answer the following questions. My concern is making the inference here. We presume they understood what they read. You're an exceptionally intelligent lawyer. You've been doing this for a long time. These jurors aren't lawyers. And the fact that you're making a very, a creative and intelligent argument here today strikes me as pretty hard to put that on. That's what the jury understood. I mean, shouldn't the defendant have gotten a chance to say, wait a minute, there's a problem? That's what happens in civil cases.
I will say I have relied on that presumption many times, and I'll rely on it again today.
And I wasn't disparaging you
Oh,
by all means.
If you look at the instructions carefully, there's two features of the instructions I think are very important. First is, unlike the case in Sanchez and unlike the case with the position or the pattern of abuse interrogatory, if you look where they check the box, it's not tantamount, if you read it, to a finding of not guilty. It just says the incident. It doesn't say we do not find that the sexual assault did not happen and this incident did not happen. It just lists incident, which, as this court said in Sanchez, when it's just that, because it's not referencing to the substantive offense, it doesn't say anything about the substantive offense. So I would disagree with the very premise of that question, which assumes that this is tantamount to a acquittal on the substantive offense. In addition, because we do presume that the jury reads it, there's a very important distinction between what that interrogatory says, and it says conduct before it lists the events. It doesn't say sexual assault, it says conduct. All of the other sexual assault on a child, pattern of abuse context, they deal with incident. And as we argued, conduct, I think if you're a jury, and if we do presume that they read it correctly and we're limited by the language, is much broader than incident. Conduct, especially with the title, where it says both pattern, position of trust and pattern of abuse, could be viewed to have incorporated both of those charges. And I think so that's supported both by the text and also when if you think about the character of the instructions. Because if you remember, we had 5 incidents alleged on the sex assault pattern of abuse, and we had 4 incidents alleged on position of trust. That one only lists the 4. So I think that also just underscores that the jury would have read it as covering just position of trust. And defense counsel mentioned the trial court even told them that when he was describing the instructions.
So what do you do, and thanks for your patience with me, Mr. Lee. The question says if you find the defendant guilty of either SCOC or position of trust, then you must answer the following interrogatories. They acquitted him of position of trust, so had they read it, they would not have gone on to answer. But I suppose they may be finding him guilty of SCOC or think they are, and then go on to answer and say everything's not proved. That's my concern. That strikes me as inconsistent to say we're finding him guilty on the one hand and saying everything was not proved on the other.
And there's really just 2 ways you can look at the instruction, I think, from the court's point of view. You can read it literally, and literally, I think if the jury could have read it as, if we find him guilty of either, we fill it out. And then we get to the conduct, which is, did they prove it as to both? And they did not. They did not find that we proved it as to position of trust. So if you're going to read it literally, then they're not antagonistic. If this court chooses not to read it literally, or I think to underscore how the literal reading of it, I think look at it logically.
And forgive me, Mr. Lee, and I think I'm not tracking with your argument, and I apologize. I think I'm reading it literally, but maybe I'm not following you, the incident versus conduct, so please try me again.
So the jury is told on the instruction that if you find him guilty of one or other, you need to fill out the remaining form. And then it's, did you find these incidents proved as to the conduct? And I'm saying when it says conduct, that references whether or not those incidents were proved both as to position of trust and as to sex assault on a child. If it just would have said incident, or if in Sanchez, if they had said sex assault on a child where the boxes are checked, then I think there might be a stronger argument, but that's not what it said. So I think if you read it strictly as it's termed, and we presume that they do and they follow it, there is no conflict.
And what about the actual verdict form? What was the instruction on the problematic verdict form in terms of whether they should fill it out or not?
On the interrogatory for the unanimity for the both pattern of trust, and I think that is what we're discussing. So that's the one where it says conduct.
But that tells them do not answer, that the only time they shouldn't answer it is if they found the defendant not guilty of both charges. Is that how you read it as well?
No, I'm reading it as it's saying you have to answer if you found him guilty of one or the other.
Right.
It's a very weirdly
We're
worded
saying
instruction.
the same thing, yeah.
Yeah, so it's if you, and I think fully consistently with the instruction, the jury could have, there's no necessary conflict in the instructions, which again, if we're invoking from the civil rules also, we have to review it that way, because that is what all the civil cases say. We have to do whatever we can to reconcile the verdicts. And here the verdicts can be reconciled. Again, and I think apart from being, it's just, if you look at the context, I think reasonably, that is what the jury thought. Given the context, what it says, the character, what the trial court said when it was describing the instructions, when it told them on the October, I think it's 17th transcript when discussing the instructions on page 176, that it applied to the pattern count. And the defense counsel is correct that later then reads instructions says and or, but that doesn't get past my literal reading, which means that you could say that it applied to both, but she had to answer it if you found him guilty of one.
If we find there's no waiver here, what standard should we apply? Are we looking at plain error? Are we looking at harmless error?
Plain error. The issue is whether or not, I guess for the first time, it was argued that because there is no default, then plain error shouldn't apply. Our position would be that there was a default, given the fact that if this court were not to find invited or knowing waiver, certainly defense counsel was given the opportunity and is presumed to have known that they could have required the court to have read the verdicts.
But why is that on the defendant? Why isn't the first, the one person in the room who understood there was or should have understood there was a problem was the judge? I don't know why the judge didn't raise it. But why is it on the defendant at the risk of not being heard at all, waived? The prosecutor has an equal interest in making sure the verdict is valid. Why don't we say it's the prosecutor's burden? Why is it on the defendant?
I think normally when we're dealing with kind of those equity issues, that goes more towards a waiver. When we're dealing with just the forfeiture, the part of the reason why we're doing that is we want counsel to help the court avoid errors.
But counsel here had no reason to know there was a problem. I suppose, with 20/20 hindsight, not sitting in a courtroom when you're in shock from getting a verdict, which I've suffered. He just read an interrogatory answer, says guilty, everything is consistent. What else is there to poll? I lost. And then it occurs to you after, wait a minute, there was another verdict form. Or an interrogatory. Where's the waiver? Where's the even the neglect? If he heard an inconsistency and said nothing, I get neglect.
Okay,
I never heard it.
Oh, I apologize.
No, you're fine.
So let me go down the line. So because I do think it's invited. If it's not invited, it's waived. And if it's not waived, it's certainly defaulted. So I think we need to look very carefully at what the claim on appeal is, and then that kind of dictates what standard review should apply. So in this case, what their argument necessarily boils down to is, since we have the verdict form finding him guilty with unanimity instruction, and then we have the court finding the pattern interrogatory where they found all the incidents proved, and then we have the jury polled saying, yes, we found all of those things, the defense's argument is that that's not enough. That absolutely has to be their argument because there's no dispute that those three things happened. So if that's the argument, then when the trial court said those three things and said, I'm going to enter the judgment of conviction unless anyone has anything else, they want to poll the jury anymore, then I think that is affirmative conduct. And in this case, it goes beyond affirmative conduct. And I know this court's had some other cases recently where it's been dealing with invited error, but I don't think Rediger changed invited error. It clarified it and just brought it back to what it always was.
How could the defendant possibly have known that there was an error to be invited? How could the defendant's lawyer hadn't seen the interrogatory that was marked not proven? I just don't see how this could be invited error.
Well, for invited error, it doesn't necessarily require defense counsel's knowledge so long as you induce the error. So for example, like a lesser not included, it might not be a smart idea to do it, but if you're the one who does the conduct, then invited error applies. Because it's based on collateral estoppel, which I think is fairly uncontroversial, which should be that if you help to induce the error, then you can't complain about it on appeal. So the issue really is detrimental reliance as opposed to how knowing or strategic it was on defense counsel. I think that goes to waiver, but less so for invited error. So I'm saying in this case, given the precise nature of the error, which is with these three things, conviction couldn't enter, you needed more from the jury. When the court said, I have these three things, I'm going to enter judgment of conviction, here's your chance. Do you want to ask them anything more? Or else I'm going to enter judgment of conviction based on these three things. When you say no, the court relied on that and found you guilty without more.
But isn't the... Oh, go ahead.
Counsel did not have a complete information. Had the other interrogatory been read out loud, I would agree with you, because in that point, you've been presented with the conflict, you haven't said anything, I agree. But having not been presented with that conflict, having no basis to think there was a conflict, I struggle to see why the onus falls on the defendant to raise an objection, at least at that juncture.
I would say counsel, in this case, given these facts, counsel certainly was aware that the jury was given that additional instruction. Counsel's also aware that the court didn't read it. The counsel's also aware that the court didn't pull the jury on it. And counsel was aware that the court, having not done those things, but having read the general verdict, read the pattern, and had the jury all assent that that was their verdict, was going to enter, having done those three things, but not having done those others. So I think given the complete record, counsel, if there was an issue, counsel should have objected, and the failure to do so invited the error, or at a minimum, was a waiver.
Ultimately, you're going to argue the fourth among your 4 points, I think they were at the outset. It's harmless anyway because the polling cured it, right? So I guess I'm struggling to understand why we're doing all these contortions around the standard. You know, I guess I get it just at some level, but if the polling cured it, all of this doesn't really matter, right? Even
Correct.
Yeah.
And if there's no unanimity problem to begin with, it also doesn't matter.
So help me understand, let's talk about the polling. The jury's answers were correct. Or is that your verdict? So the three I read, yep. Why does that alert anybody to an error? It was correct, what they said, but they still didn't get a chance to explain this arguably inconsistent one. I mean, that's the concern why I have a little bit of trouble, but I'm certainly, push back here. How that solves the problem. When their answers were correct, that's what we said on those three forms.
I would say whatever ambiguities we have in this case regarding the verdicts, it's not on the ones that the court read. So even the Morris case that defense counsel cites from 10th Circuit and relies on heavily says that polling is certainly one means of ensuring unanimity. The court read to the jury that the verdict that they had found unanimously found beyond reasonable doubt that the defendant committed the crime of sex assault, that they all had found each of the incidents proven. Each juror assented to that. So there's
but they also found each of the ones not proven. That's what you're just ignoring that. It feels to me like you're not insulting you at all. That's my problem. If they were all read and there's a chance to explain, and maybe the jury would have explained, well, we thought that meant pattern when the court sent them back, and we wouldn't be here. That's the problem. And said, here we are years after this trial, guessing. That's the issue.
I guess in my mind, there's really only two ways you can look at the verdicts. One is that they're not in conflict at all, which then the jury's polling is just fully consistent. The other one is if you view them in conflict, which I don't think you can again, because again, it's how they're phrased. It doesn't actually reference the elementals, as was the problem in Sanchez. As Justice Samore explained, they're mutually exclusive then. If the court says, did you find he committed sex assault on a child? Yes. Then necessarily they didn't mean no.
Well, it's even more than that, isn't it? Because it was that and is that your verdict, right? Isn't that the way the polling went?
Yes.
So not only did you write that thing in the jury room, but now I'm asking you the question essentially again, which gives more significance, arguably, to the polling, right? Because it's saying even now you're persisting in that.
Absolutely. So I guess what's interesting to me also in this case is, had the court gone further, it would have been the same polling that we already have, and that would have been enough. So I don't know how it wouldn't be given what we have and how the court phrased it.
But let's play that out. So the court read the inconsistent one. Is that your verdict? So I've read two sets of interrogatories. One said all four were proved and one said all four were not proved. Doesn't that would have presented the issue? It would not have solved it because now we have the inconsistency front, or the arguable inconsistency front and center.
Oh, so I guess what I was trying to reference was...
Sorry.
Oh, my apologies as well. So Justice Hart asked the question earlier of, was there a reason why the court pulled the way it did? And I guess in my mind, I kind of thought that, so let's say the court had saw the verdicts. One way to uphold the jury, rather than asking them individually about the different verdicts, because if you do view them as inconsistent, then they are zero-sum, they are mutually exclusive, would be, do you, and is it your verdict that he did commit the crime of sexual assault, that he did commit each and every act? And had they said yes, as they did here, you wouldn't have had it gone any further. That would have cured the ambiguity.
But you agree that, I think what Justice Gabriel was trying to get at is, the situation we have here is different than if the judge had read all the verdicts and all the interrogatories, including the inconsistent ones, and then had simply asked, is this and was this your verdict? That would have solved nothing in your position, right, or in your opinion.
Sorry, had the court read all the verdicts?
Right, and then simply asked, are these your verdicts? That polling would have done nothing in that case.
I would think in that instance, it might have been, well, it still would have to be whether or not they're viewed as being inconsistent or not. So I guess my position would be that the result would still be the same in that case. The polling, that would just show that they found that the position of trust counts were not proven.
I'm a little confused on this, too. Let me back up just a second. Let's assume there's no polling at all. Let's get rid of that. And you just have these verdicts. Now, I understand you're trying to say, you're making an argument why they are not inconsistent, really. One could interpret them in such a way. Let's say we don't go for that, or that's not the case. What would findings like this, what would they result in?
So in my view, at worst, these are inconsistent interrogatories, which do not present a cognizable reversible claim. This court has made very clear what kind of inconsistent verdicts are reversible.
And what kind are those?
It'd be the two in Powell. So it's the conspiracy and when there's legal impossibility. It's not lenity, which I think is where this one would be, where the jury decides to not find you guilty. It's when your two positive verdicts would necessarily be legally inconsistent, which is not present here. So this would fit under neither one of the two Powell exceptions. So even if this court were to disagree that they're not in conflict, at most, this is an inconsistent interrogatory claim, which is just, it's not reversible. It's not cognizable.
Mr. Lee, would you agree with me that ideally the judge should have clarified this at the time, right? Should have said, wow, we've got two different verdicts here. Counsel, should we resubmit them? I mean, he should have cleared it up, right?
And I think it's unclear to me, obviously, it's not clear to the record on what the judge was thinking. But I guess what's interesting to me is the judge
was this ideal?
I think had the judge seen it, it would have, to poll it that way, it would have been the same result. Because I think if you're asking the jury...
That's not what I'm asking you. I'm asking you how the judge handled it. Is that ideal? Would you say, this is how you should do it?
And I'm saying if... I'm saying I'm unaware of
no, don't you?
No. I'm going to agree. I'm saying the record's unclear as to the premise. So yes, I would agree. If the judge didn't look at it, that's not best practice. I'm just saying it's unclear to me, and I just think the record is silent, and I don't want to say the judge was unaware of something when the record doesn't say
something went wrong. I'm not saying anything, the judge was negligent. I'm just saying that this is not how we would like to have it done. I mean, it should be clearer, correct?
Yes, but I'm saying there is the theoretical possibility, and the record's just unclear on this, that the judge saw the inconsistency, and that's what the polling was meant.
Okay, so I guess then the question is, when we have something that's unclear, what can the court later do to provide clarity? I mean, are we not back to what we were talking about of trying to draw inferences and try and speculate's probably too strong a word, but try to infer what the jury really meant?
So the principle underlying that would be that we do not use speculation to overturn verdicts we know the jury made. And I would say in this case, their argument is the argument that's asking this court to speculate. Because the only thing we don't know, assuming this court disagrees with me on that they're not inconsistent, is as to what the jury meant on that interrogatory. We absolutely know, based on the other pattern interrogatory form and the jury polling, that those were their verdicts, that they did find that the defendant committed sex assault on a child and pattern of all those 5 offenses. Each juror said that that was in fact what they found. So we're not asking for speculation. We're asking this court to accept the verdicts as the jury confirmed, both in writing and in court in polling. The only ambiguity that we might have, and in my mind is non-ambiguity, is interrogatory. And I 100% agree that under this court's case law, it can't use that speculation to overturn the jury's verdict.
Hearing a deafening silence.
I'm deciding whether I want to argue waiver or not. I do have 3 minutes. Okay, I was looking at this court's faces. It doesn't look like they want to hear about waiver. So at this point, I would ask this court to affirm the defense conviction and the opinion of the Court of Appeals. Thank you.
Thank you. I show about 2 minutes and 3 seconds.
Okay, I'll try to make the best of it. So just a few quick points. One is that in this conduct versus incident, trying to differentiate between the interrogatories, I discussed that in the briefing. I would invite you to read that because both of the interrogatories talk about acts, okay? That's what the jury is looking at. They're looking at the acts. Whether you call it conduct going in or incidents going in, they are looking at the acts. In terms of polling, respectfully, Justice Hood, I think that when you ask the jury not about all their verdicts, and one of them is bizarre, the polling hasn't taken care of it. The jury has not been asked on the record to like Justice Boatwright suggested, in the best of circumstances, the court would go, what has happened here? And would consult with counsel and say, look, we need to go back to them and talk to them about this. In terms of the Powell issue, we are talking about, if we're going down the Powell road, we are talking about, well, we look at lenity, we have an acquittal and we have a guilty verdict, and don't ask, why the jury reached that. If we have an acquittal, it's an acquittal on the substantive offense. And that is, I'm sure, not what Mr. Lee is advocating. Finally, I think what Sanchez says, and I would respectfully disagree with Mr. Lee, we do not use speculation to overturn a verdict. Actually, we don't use speculation to find a person guilty. And that is, Mr. Rail has been in prison for the last however many years. He has no criminal record except for a DWAI, all because we can't figure out what the jury found here, and that's not right. So I would respectfully ask that you overturn his conviction. Thank you.
Thank you. Appreciate the arguments of both counsel. The case will stand submitted, and the court will be in recess.